Good morning, good afternoon, or good evening from wherever you're watching or listening. My name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. In today's lecture, we're going to provide another installation into our series on the Lincoln-Douglas debates, going on to number 6. So if you haven't gone back and watched 1 through 5, I would highly encourage you to do so that way you can really see the true intentions and beliefs, the policies of one of the most notorious notable figures in U.S. history, that of course being Mr. Abraham Lincoln. Now, Stephen Douglas made his notable contributions as well, but is nowhere nearly as name recognized as Mr. Abraham Lincoln. So let's go ahead and jump on over to the Lincoln-Douglas debate transcripts. Like I said, we're going on to the 6th one. It took place in Quincy on October 13th, 1858. Since Mr. Douglas started the last debate, Mr. Lincoln will start this one, and he says this. Ladies and gentlemen, I have had no immediate conference with Judge Douglas, but I will venture to say that he and I will perfectly agree that your entire silence, both when I speak and when he speaks, will be most agreeable to us. When the judge says he wouldn't have believed of Abraham Lincoln, that he would have made such an attempt as that, he reminds me of the fact that he entered upon this canvas with the purpose to treat me courteously. That touched me somewhat. It sets me to thinking. I was aware, when it was first agreed that Judge Douglas and I were to have these 7 joint discussions, that they were the successive acts of a drama. Perhaps I should say, to be enacted, not merely in the face of audiences like this, but in the face of the nation, and to some extent, by my relation to him, and not from anything in myself, in the face of the world. And I am anxious that they should be conducted with dignity, and in the good temper which would be befitting the vast audience before which it was conducted. We have in this nation this element of domestic slavery. It is a matter of absolute certainty that it is a disturbing element. It is the opinion of all the great men who have expressed an opinion upon it that it is a dangerous element. We keep up a controversy in regard to it. That controversy necessarily springs from difference of opinion, and if we can learn exactly and reduce to the lowest element what this difference of opinion is, we shall perhaps be better prepared for discussing the different systems of policy that we would propose in regard to that disturbing element. I suggest that the difference of opinion, reduced to its lowest terms, is no other than the difference between the men who think slavery a wrong and those who do not think it wrong. The Republican Party thinks it is wrong. We think it is a moral, a social, and a political wrong. We think it is a wrong not confining itself merely to the persons or the states where it exists, but that it is a wrong in its tendency, to say the least, that extends itself to the existence of the whole nation. Because we think it wrong, we propose a course of policy that shall deal with it as a wrong. We deal with it as with any other wrong, insofar as we can prevent its growing any larger, and so deal with it that in the run of time there may be some promise of an end to it. We have a due regard to the actual presence of it amongst us, and the difficulties of getting rid of it in any satisfactory way, and all the constitutional obligations thrown about it. I suppose that in reference both to its actual existence in the nation and to our constitutional obligations, we have no right at all to disturb it in the states where it exists, and we profess that we have no more inclination to disturb it than we have the right to do it. We go further than that. We don't propose to disturb it where, in one instance, we think the Constitution would permit us. We think the Constitution would permit us to disturb it in the District of Columbia. Still, we do not propose to do that unless it should be in terms which I don't suppose the nation is very likely soon to agree to, the terms of making the emancipation gradual and compensating the unwilling owners. Where we suppose we have the constitutional right, we restrain ourselves in reference to the actual existence of the institution and the difficulties thrown about it. We also oppose it as an evil, so far as it seeks to spread itself. We insist on the policy that shall restrict it to its present limits. We don't suppose that in doing this, we violate anything due to the actual presence of the institution or anything due to the constitutional guarantees thrown around it. We oppose the Dred Scott decision in a certain way, upon which I ought perhaps to address you a few words. We do not propose that when Dred Scott has been decided to be a slave by the court, we as a mob will decide him to be free. We do not propose that when any other one or 1,000 shall be decided by that court to be slaves, we will in any violent way disturb the rights of property thus settled. But we nevertheless do oppose that decision as a political rule, which shall be binding on the voter to vote for nobody who thinks it wrong, which shall be binding on the members of Congress or the President to favor no measure that does not actually concur with the principles of that decision. We do not propose to be bound by it as a political rule in that way because we think it lays the foundation, not merely of enlarging and spreading out what we consider an evil, but it lays the foundation for spreading that evil into the states themselves. We propose so resisting it as to have it reversed if we can, and a new judicial rule established upon this subject. I will add this, that if there be any man who does not believe that slavery is wrong in the three aspects which I have mentioned, or in any one of them, that man is misplaced and ought to leave us. While, on the other hand, if there be any man in the Republican Party who is impatient over the necessity springing from its actual presence, and is impatient of the constitutional guarantees thrown around it, and would act in disregard of these, he too is misplaced, standing with us. He will find his place somewhere else, for we have a due regard, so far as we are capable of understanding them, for all these things. This, gentlemen, as well as I can give it, is a plain statement of our principles in their enormity. I will say now that there is a sentiment in the country contrary to me, a sentiment which holds that slavery is not wrong, and therefore it goes for the policy that does not propose dealing with it as a wrong. That policy is the Democratic policy, and that sentiment is the Democratic sentiment. If there be a doubt in the mind of anyone of this vast audience that this is really the central idea of the Democratic Party in relation to the subject, I ask him to bear with me while I state a few things tending, as I think, to prove that proposition. In the first place, the leading man, I think I may do my friend Judge Douglas the honor of calling him such, advocating the present Democratic policy, never himself says it is a wrong. He has the high distinction, so far as I know, of never having said slavery is either right or wrong. Almost everybody else says one or the other, but the judge never does. If there be a man in the Democratic Party who thinks it is wrong, and yet clings to that party, suggest to him in the first place that his leader don't talk as he does, for he never says that it is wrong. In the second place, I suggest to him that if he will examine the policy proposed to be carried forward, he will find that he carefully excludes the idea that there is anything wrong in it. If you will examine the arguments that are made on it, you will find that everyone carefully excludes the idea that there is anything wrong in slavery. Perhaps that Democrat who says that he is as much opposed to slavery as I am will tell me that I am wrong about this. I wish him to examine his own course in regard to this matter a moment, and then see if his opinion will not be changed a little. You say it is wrong, but don't you constantly object to anybody else saying so? Do you not constantly argue that this is not the right place to oppose it? You say it must not be opposed in the free states because slavery is not here. It must not be opposed in the slave states because it is there. It must not be opposed in politics because that will make a fuss. It must not be opposed in the pulpit because it is not religion. Then where is the place to oppose it? There is no suitable place to oppose it. There is no place in the country to oppose this evil overspreading the continent which you say yourself is coming. Frank Blair and Gratz Brown tried to get up a system of gradual emancipation in Missouri, had an election in August, and got beat. And you, Mr. Democrat, threw up your hat and howled, "Hooray for democracy." So I say again, that in regard to the arguments that are made, when Judge Douglas says he, quote, don't care whether slavery is voted up or voted down, whether he means that as an individual expression of sentiment or only as a sort of statement of his views on national policy. It is alike true to say that he can thus argue logically if he don't see anything wrong in it. But he cannot say so logically if he admits that slavery is wrong. He cannot say that he would as soon see a wrong voted up as voted down. When Judge Douglas says that whoever or whatever community wants slaves, they have a right to have them, he is perfectly logical if there is nothing wrong in the institution. It's actually a non sequitur, logical fallacy. But if you admit that it is wrong, he cannot logically say that anybody has a right to do wrong. When he says that slave property and horse and hog property are alike to be allowed to go into the territories upon the principles of equality, he is reasoning truly if there is no difference between them as property. But if the one is property held rightfully and the other is wrong, then there is no equality between the right and wrong. So that turn it in any way you can. In all the arguments sustaining the democratic policy and in that policy itself, there is a carefully studied exclusion of the idea that there is anything wrong in slavery. Let us understand this. I am not, just here, trying to prove that we are right and they are wrong. I have been stating where we and they stand and trying to show what is the real difference between us. And I now say that whenever we can get the question distinctly stated, can get all these men who believe that slavery is in some of these respects wrong, to stand and act with us in treating it as a wrong. Then, and not till then, I think we will in some way come to an end of this slavery agitation. So here is Mr. Douglas's reply. I'll do my best to keep my comments to myself. It's going to be difficult, though, because a lot of the arguments and comments made by Mr. Lincoln are not on a moral perspective, but on a argumentative perspective, problematic. So let's hear what Mr. Douglas says in reply. He says, Mr. Lincoln pretends that after I had so quoted those resolutions, he discovered that they had never been adopted at Springfield. I will now show you that I stated with entire fairness, as soon as it was made known to me, that there was a mistake about the spot where the resolutions had been adopted, although their truthfulness as a declaration of the principles of the Republican Party had not and could not be questioned. I did not wait for Lincoln to point out the mistake, but the moment I discovered it, I made a speech and published it to the world correcting the error. I corrected it myself, as a gentleman and an honest man, and as I always feel proud to do when I have made a mistake. I wish Mr. Lincoln could show that he has acted with equal fairness and truthfulness when I have convinced him that he has been mistaken. I will give you an illustration to show you how he acts in a similar case. In a speech at Springfield, he charged Chief Justice Taney and his associates, President Pierce, President Buchanan, and myself, with having entered into a conspiracy at the time the Nebraska bill was introduced, by which the Dred Scott decision was to be made by the Supreme Court in order to carry slavery everywhere under the Constitution. I called his attention to the fact that at the time alluded to it, the introduction of the Nebraska bill, it was not possible that such a conspiracy could have been entered into for the reason that the Dred Scott case had never been taken before the Supreme Court and was not taken before it for a year after, and I asked him to take back that charge. Did he do it? I showed him that it was impossible that the charge could be true. I proved it by the record, and I then called upon him to retract his false charge. What was his answer? Instead of coming out like an honest man and doing so, he reiterated the charge and said that if the case had not gone up to the Supreme Court from the courts of Missouri at the time he charged that the judges of the Supreme Court entered into the conspiracy, yet that there was an understanding with the Democratic owners of Dred Scott that they would take it up. I have since asked him who the Democratic owners of Dred Scott were, but he could not tell, and why. Because there were no such Democratic owners in existence. Dred Scott at the time was owned by the Reverend Dr. Chaffee, an abolition member of Congress of Springfield, Massachusetts, in right of his wife. He was owned by one of Lincoln's friends, and not by Democrats at all. His case was conducted in court by abolition lawyers, so that both the prosecution and the defense were in the hands of the abolition political friends of Mr. Lincoln. Notwithstanding, I thus proved by the record that his charge against the Supreme Court was false, instead of taking it back. He resorted to another. Notwithstanding, I thus proved by the record that his charge against the Supreme Court was false. Instead of taking it back, he resorted to another false charge to sustain the infamy of it. He also charged President Buchanan with having been a party to the conspiracy. I directed his attention to the fact that the charge could not possibly be true for the reason that at the time specified, Mr. Buchanan was not in America, but was 3,000 miles off representing the United States at the Court of St. James and had been there for a year previous, and did not return until 3 years afterward. Yet, I never could get Mr. Lincoln to take back his false charge, although I have called upon him over and over again. He refuses to do it and either remains silent or resorts to other tricks to try and palm his slander off on the country. Therein you will find the difference between Mr. Lincoln and myself. When I make a mistake, as an honest man, I correct it without being asked to do so. But when he makes a false charge, he sticks to it and never corrects it. One word more in regard to these resolutions. I quoted them at Ottawa merely to ask Mr. Lincoln whether he stood on that platform. That was the purpose for which I quoted them. I did not think that I had a right to put idle questions to him, and I first laid a foundation for my questions by showing that the principles which I wished him either to affirm or deny had been adopted by some portion of his friends, at least as their creed. Hence, I read the resolutions and put the questions to him, and then he let me untie my tongue. And he then refused to answer them. Subsequently, 1 week and afterward, he did answer a part of them, but the others he has not answered up to this day. The Dred Scott decision was pronounced by the highest tribunal on earth. From that decision, there is no appeal this side of heaven. Yet Mr. Lincoln says he's going to reverse that decision. By what tribunal will he reverse it? Will he appeal to a mob? Does he intend to appeal to violence, to lynch law? Will he stir up strife and rebellion in the land and overthrow the court by violence? He does not deign to tell you how he will reverse the Dred Scott decision, but keeps appealing each day from the Supreme Court of the United States to political meetings in the country. He wants me to argue with you the merits of each point of that decision before this political meeting. I say to you, with all due respect, that I choose to abide by the decisions of the Supreme Court as they are pronounced. It is not for me to inquire after a decision is made whether I like it in all the points or not. When I used to practice law with Lincoln, I never knew him to be beat in a case that he did not get mad at the judge and talk about appealing. And when I got beat, I generally thought the court was wrong, but I never dreamed of going out of the courthouse and making a stump speech to the people against the judge merely because I had found out that I did not know the law as well as he did. If the decision did not suit me, I appealed until I got to the Supreme Court. And then if that court, the highest tribunal in the world, decided against me, I was satisfied, because it is the duty of every law-abiding man to obey the constitutions, the laws, and the constituted authorities. He who attempts to stir up odium and rebellion in the country against the constituted authorities is stimulating the passions of men to resort to violence and to mobs instead of to the law. Hence, I tell you that I take the decisions of the Supreme Court as the law of the land, and I intend to obey them as such. But Mr. Lincoln says that I will not answer his question as to what I would do in the event of the court making so ridiculous a decision, as he imagines they would be deciding that the free state of Illinois could not prohibit slavery within her own limits. I told him at Freeport why I would not answer such a question. I told him that there was not a man possessing any brains in America, lawyer or not, who ever dreamed that such a thing could be done. I told him then, as I do now, that by all the principles set forth in the Dred Scott decision, it is impossible. I told him then, as I do now, that it is an insult to men's understanding and a gross calumny on the court to presume in advance that it was going to degrade itself so low as to make a decision known to be in direct violation of the Constitution. If each state will only agree to mind its own business and let its neighbors alone, there will be peace forever between us. We in Illinois tried slavery when a territory and found it was not good for us in this climate, and with our surroundings, and hence we abolished it. We then adopted a free state constitution, as we had a right to do. In this state, we have declared that a Negro shall not be a citizen, and we have also declared that he shall not be a slave. We had a right to adopt that policy. Missouri has just as good a right to adopt the other policy. I am now speaking of rights under the Constitution and not of moral or religious rights. That's the main contention against Mr. Lincoln's position. Notice how Mr. Lincoln says evil, 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 a moral argument, and Judge Douglas is saying, sure, but what does the Constitution allow? I do not discuss the morals of the people of Missouri, but let them settle that matter for themselves. I hold that the people of the slaveholding states are civilized men as well as ourselves, and that they bear consciences as well as we, and that they are accountable to God and their posterity, and not to us. It is for them to decide, therefore, the moral and religious right of the slavery question for themselves within their own limits. I assert that they had as much right under the Constitution to adopt the system of policy which they have as we had to adopt ours. So it is with every other state in this union. Let each state stand firmly by that great constitutional right, let each state mind its own business, and let its neighbors alone, and there will be no trouble on this question. If we will stand by that principle, then Mr. Lincoln will find that this republic can exist forever, divided into free and slave states as our fathers made it and the people of each state have decided. Stand by that great principle, and we can go on as we have done, increasing in wealth, in population, in power, and in all the elements of greatness, until we shall be the admiration and terror of the world. We can go on and enlarge as our population increases, require more room, until we make this continent one ocean-bound republic. Under that principle, the United States can perform that great mission, that destiny, which Providence has marked out for us. Under that principle, we can receive with entire safety that stream of intelligence which is constantly flowing from the old world to the new, filling up our prairies, clearing our wildernesses, and building cities, towns, railroads, and other internal improvements, and thus make this the asylum of the oppressed of the whole earth. We have this great mission to perform, and it can only be performed by adhering faithfully to that principle of self-government on which our institutions were all established. Go ahead and highlight that. From we have this great mission to we're all established. A fair way to summarize the understanding of the founding generation. I repeat that the principle is the right of each state, each territory to decide this slavery question for itself, to have slavery or not as it chooses, and it does not become Mr. Lincoln or anybody else to tell the people of Kentucky that they have no consciences, that they are living in a state of iniquity, and that they are cherishing an institution to their bosoms in violation of the law of God. Better for him to adopt the doctrine of, quote, judge not, lest ye shall be judged. Let him perform his own duty at home, and he will have a better fate in the future. I think there are objects of charity enough in the free states to excite the sympathies and open the pockets of all the benevolence we have amongst us without going abroad in search of Negroes of whose condition we know nothing. We have enough objects of charity at home, and it is our duty to take care of our own poor and our own suffering before we go abroad to intermeddle with other people's business. My friends, I am told that my time is within 2 minutes of expiring. I have omitted many topics that I would like to discuss before you at length. There were many points touched by Mr. Lincoln that I have not been able to take up for the want of time. I have hurried over each subject that I have discussed as rapidly as possible so as to omit but few, but 1 hour and a half is not time sufficient for a man to discuss at length one half of the great questions which are now dividing the public mind. In conclusion, I desire to return to you my grateful acknowledgments for the kindness and the courtesy with which you have listened to me. It is something remarkable that in an audience as vast as this, composed of men of opposite politics and views, with their passions highly excited, there should be so much courtesy, kindness, and respect exhibited not only toward one another, but toward the speakers. And I feel that it is due to you that I should thus express my gratitude for the kindness with which you have treated me. So here is Mr. Lincoln's reply in the last speech of this debate. Mr. Lincoln says this: My friends, since Judge Douglas has said to you in his conclusion that he had not time in an hour and a half to answer all I had said in an hour, it follows, of course, that I will not be able to answer in half an hour all that he said in an hour and a half. I wish to return to Judge Douglas my profound thanks for his public enunciation here today, to be put on record that his system of policy in regard to the institution of slavery contemplates that it shall last forever. We are getting a little nearer to the true issue of this controversy, and I am profoundly grateful for this one sentence. Judge Douglas asks you, quote, why cannot the institution of slavery, or rather, why cannot the nation, part slave and part free, continue as our fathers made it forever? In the first place, I insist that our fathers did not make this nation half slave and half free, or part slave and part free. I insist that they found in the institution of slavery existing here. They did not make it so, but they left it so because they knew no way to get rid of it at that time. When Judge Douglas undertakes to say that, as a matter of choice, the fathers of the government made this nation part slave and part free, he assumes what is historically a falsehood. More than that, when the fathers of the government cut off the source of slavery by the abolition of the slave trade and adopted a system of restricting it from the new territories where it had not existed, I maintain that they placed it where they understood, and all sensible men understood. It was in the course of the ultimate extinction. And when Judge Douglas asked me why it cannot continue as our fathers made it, I asked him why he and his friends could not let it remain as our fathers made it. It is precisely all I ask of him in relation to the institution of slavery, that it shall be placed upon the basis that our fathers placed it upon. Mr. Brooks of South Carolina once said, and truly said, that when this government was established, no one expected the institution of slavery to last until this day, and that the men who formed this government were wiser and better than the men of these days. But the men of these days had experience which the fathers had not, and that experience had taught them the invention of the cotton gin, and this had made the perpetuation of the institution of slavery a necessity in this country. Judge Douglas could not let it stand upon the basis upon which our fathers placed it, but removed it, and put it upon the cotton gin basis. It is a question, therefore, for him and his friends to answer why they could not let it remain where the fathers of the government originally placed it. The truth about the matter is this. Judge Douglas has sung paeans. I think it's paeans. I forget the pronunciation of that word. Judge Douglas has sung paeans to his, quote, popular sovereignty doctrine until his Supreme Court, cooperating with him, has squatted his squatter sovereignty out. But he will keep up this species of humbuggery about squatter sovereignty. He has at last invented this sort of do-nothing sovereignty, that the people may exclude slavery by a sort of sovereignty that is exercised by doing nothing at all. Is not that running his popular sovereignty down awfully? Has it not got down as thin as the homeopathic soup that was made by boiling the shadow of a pigeon that had starved to death? But at last, when it is brought to the test of close reasoning, there is not even that thin decoction of it left. It is a presumption impossible in the domain of thought. It is precisely no other than the putting of that unphilosophical proposition, of that most unphilosophical proposition, that two bodies can occupy the same space at the same time. The Dred Scott decision covers the whole ground, and while it occupies it, there is no room even for the shadow of a starved pigeon to occupy the same ground. The judge wants to know why I won't withdraw the charge in regard to a conspiracy to make slavery national, as he has withdrawn the one he made. May it please his worship, I will withdraw it when it is proven false on me, as that was proven false on him. I will add a little more than that. I will withdraw it whenever a reasonable man shall be brought to believe that the charge is not true. I have asked Judge Douglas's attention to certain matters of fact tending to prove the charge of a conspiracy to nationalize slavery, and he says he convinces me that this is all untrue because Buchanan was not in the country at that time, and because the Dred Scott case had not then gotten to the Supreme Court. And he says that I say the Democratic owners of Dred Scott got up the case. I never did say that. I defy Judge Douglas to show that I ever said so, for I never uttered it. Says here, one of Mr. Judge Douglas's reporters gesticulated affirmatively at Mr. Lincoln. So back to Mr. Lincoln. I don't care if your hireling does say I did. I tell you myself that I never said the Democratic owners of Dred Scott got up the case. I have never pretended to know whether Dred Scott's owners were Democrats, or abolitionists, or free soilers, or border ruffians. I have said that there is evidence about the case tending to show that it was a made-up case for the purpose of getting that decision. I have said that that evidence was very strong in the fact that when Dred Scott was declared to be a slave, the owner of him made him free, showing that he had had the case tried and the question settled for such use as could be made of that decision. He cared nothing about the property thus declared to be his by that decision. But my time is out, and I can say no more. So that is all to be said in the sixth debate. If you have any questions about what was said in the sixth debate, maybe questions about what was said in the preceding debates, or maybe there's a topic you'd like me to cover in a future lecture, go ahead and post those down in the comments, because the entire purpose of the Calhoun School of Law is to equip you with the necessary skills and information, such as this, to combat any sort of lawfare that will be waged against you, your loved ones, or your hard-earned property. So please, if you have any questions at all, go ahead and post them down in the comments. Excellent. So my name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to provide you a lot of information that plenty of bad folks would rather you not have. I hope you enjoyed this lecture, and if not, while you're down in the comments, go ahead and let me know how I can do better so I can best serve that purpose of helping you. I hope you all have a wonderful day, and until I see y'all in the next lecture for the next topic, I bid you all farewell.